Okay, there we go. So how does it feel that you're almost done with administrative law? I actually, yeah, Gay, did you want to say something?
Oh, well, we're almost done, but we're just not quite done enough.
Yeah, you're almost
Once we've done the exam, then we'll be happy, I think.
Yeah. The one thing that I observed was that, good, bad, okay. The one thing that I observed was that I think it was correct in deciding to use the case note assessment as one of the key assessments for administrative law, mainly because in the past 4 years that I've been teaching administrative law, I always had a midterm assessment and then I'd have a final assessment. The problem, however, was that students found my assessment questions a bit difficult and a lot of them tended to fail. And I felt then that there was not enough opportunity for students for scaffolding to learn a lot of the basic administrative law questions instead of having to directly answer questions. Now, the beauty of the case notes assessment is twofold. One, it allows students to dig deeper into certain cases pertaining to administrative law, so they have a deeper and a stronger grasp, at least of some cases pertaining to administrative law. But secondly, I knew that there was less likelihood for students to fail in this kind of assessment, mainly because it's not like there's a lot of leeway for students to actually pass. Unlike a problem-based question where you kind of have an idea that there is just one right answer. And so I've actually finished marking the midterm assessments pertaining to the case notes, and I'm very happy with the results. I would have assumed that had this been a midterm assessment, there would have been a huge number of students who would have failed the assessment. And to me, that would have been problematic because I don't want students moving into the final assessment with that burden of thinking that they might not make it in the final assessment again, therefore they end up failing the unit. So at least when I release the results tomorrow, there shouldn't be much angst amongst most of the students, mainly because there would have been very, very, very few who failed the midterm assessment. There would have been only about 4 or 5 students out of the 95 students. In the past, there would have been about 20 students who would have failed. And so I think that was a good thing. So I'll release the results for the case notes assessment tomorrow. Okay, so having said that, you could probably, we're going to spend the first few minutes for a drop-in session. So in case you might have any questions, then it's a chance for me to answer them. Do you have any questions, concerns, things you might want to raise?
Andrew, is it possible to get the results released tonight if you've marked all of them?
No, because I want to make sure that everything is. So there are 2 aspects of the marking. One is I've actually marked them, but the other one is to make sure that I didn't make any mistake when I put them in gradebook. So that's one. And yeah, I just want to make sure that I release it as scheduled. So they'll be out tomorrow. So I don't want to release it sooner.
No worries, thanks.
Okay. Questions? Other questions?
Manager, can you repeat for me? You said based on the case notes submitted for the first assessment.
Yeah.
That had have been the quality of those case notes. If that had been a problem-based assessment, roughly 20 would have failed this semester.
20% of the cohort, yes, would fail that assessment. So that would translate to 20% of about 100 would be about 20 students. So in the past, when I'd have a midterm assessment, about half of the students would fail the midterm assessment. But with the case notes, very few students failed. Yeah, less than 5%, I think, or less than 10%, which is good. as far as I'm concerned.
So what was it in those case notes that you would draw an inference that they would have failed a problem-based assessment?
Okay, so at least in relation to those who failed, I felt that the students didn't really put in enough effort, in the sense that it was very clear in the unit profile and in the guidelines that the case notes needed a word count limit of between 500 to 600 words. It was very clear. So if a case note had less than 500 words, that would flag to me straight away that the case note is unlikely to be able to provide a thorough discussion of the facts, the legal issues of the rules, or the importance of the case to administrative law. So that's the problem if the word count is less than what was expected and what is required in the case notes. There were some who'd still end up with marks that would pass, would constitute a pass. But for those, there were just a few who did not. There were some students who just submitted case notes with where all the case notes would have less than 500 words in the case notes, so that was problematic. We had one student who submitted only 1 out of 3 case notes. I mean, that there's simply, in that instance, no way for the student to pass. There was another group that submitted fewer than 9. Fewer than what was expected. So whether if it was a group of 2 students, they should have had 6 case notes. They only, let's say, had 5. Or if it was a group of 3 students, they should have had 9 case notes. They only had 8. So it was in these instances where the failure to submit the required minimum number of case notes that led to a huge reduction in their marks. So let me repeat, there were 2 main reasons why for this midterm assessment students failed. One, they did not submit the required number of case notes. Imagine getting a 0. That's when you average that, that's going to bring down your average marks. And secondly, there were some students who did not meet the word count requirement, and meaning they wrote below the word count, or there were some who wrote beyond 600 words, and that reduces the quality of the case notes that were written. But otherwise, if students put in the effort and submitted case notes where they had about 500 to 600 words, if I remember correctly, they mainly passed the midterm assessment. Okay, anything else?
Banjo, it's Emma.
Yeah, Emma.
Are you able to put up the answers to the quiz, please?
You mean in relation to the other choices?
The quiz that we had last week, quiz 9, I think it was.
I actually provided the answer already to the quiz, except that I only provided the correct answer. I did not give the reasons why the other choices were wrong. So I gave out the answer on Monday.
Is that in Moodle?
It was in Facebook.
Okay, I've missed it.
Okay, it's there. It's actually there. I released it on Monday, but I'll provide the full answer in the sense that I will explain why the rest of the choices were wrong. But I released the correct answer in Facebook on Monday.
Manjo, it's Peter.
Yes, Peter.
Facebook is a bad way to put that up onto the system, because it often doesn't come up on your Facebook page for 2 or 3 days.
Really? Oh, I didn't know that. Okay, thanks for telling me that.
Facebook decides on the order and everything on which things come up on, and things can be missed out for 2 or 3 days.
Really? Okay, I didn't know that. Okay, thanks for telling me that, Peter. So
that's only, sorry, I'll just explain that. That's only your news feed. If you go actually into the admin page on Facebook, it should be there. in chronological order as to when you put it up. It should be there from the minute, like from the second you put it up. It should be there, but it may take a couple of days to filter onto people's news feeds if that's what they're relying on, rather than actually going onto the page itself.
That's right. I think Louis may be correct. So there's a distinction between the news feed in your Facebook account as opposed to going to the page itself, because the moment I post it, it should be visible straight away. Yeah, but at any rate, you're correct, Peter. At least for this week, I forgot to post it in Moodle as well, but I'm going to do that tonight. So after we end the class, I'm going to flick out the answer to the weekly quiz in Moodle just to be sure.
Thanks, Manjo. That'd be great.
Okay, so it's now 7 o'clock. Is there any other question?
Yeah, just a quick question. The exam.
Yes.
Sorry, Mando.
Who's talking?
Leonie.
Leonie, yes.
Are you going to leave up all the quiz answers and all your discussion answers when you release the take-home paper, or will you be making those hidden on the Moodle site?
No, they'll be out there. They will be out there. You can see them. Note though that after the submission of the final take-home paper, the quizzes are likely going to be invisible because I need to consolidate all the quiz marks into just one single mark, which means I need to delete all of them. I will retain copies, but you will no longer see them after a while. Okay, but what? No, I'm not sure. Now, so what you could probably do is to try to copy them on your own, put it into a Word file, because I'm going to have to delete them, because when we do the grade moderation, I think around 2 weeks after the deadline for the upon the due date for the submission of grades, we are required to consolidate the marks for the quiz, because otherwise, it's a very lengthy list. It's part of the system. So just to be sure, during the private take-home, it's going to be there. After a while, you need to copy whatever quiz questions and answers there are if you want to have your own file. I muted everyone. If you need to unmute yourself, please do so. Okay, so we could probably begin with the assessment revision. Is that fine?
Excuse me, Manjo.
Yomi, yes.
Yeah, I know everyone was a bit worried about the peer review marking.
Yeah.
And now that everyone's marking has been submitted, I just wonder what was your take on how the peer review thing went, if it was up to what you expect, or yeah, I'm just curious of your opinion about the.
In general, I have seen that most students put in the effort, genuinely did their best to mark the case notes appropriately. I've had students call me and send me emails about, whether or not they were really being strict and so on. One was concerned that he was acting like some kind of a grammar Nazi. So, but in the end, a lot of them were very happy to have been exposed to the answers of their peers and to have been put in the shoes of what it is like to be a marker. So they like the exercise. And so far, I can't say that I've seen anyone playing around with the marks, because I did the process of moderation. I'm not yet through doing the moderation, mainly because there are some students who have not yet submitted the peer marks. So that's my concern there. But the ones that I've seen, they're quite good. Okay, would that be fine? So we could probably proceed. Okay, so tonight is the assessment revision. As we discussed, we're doing this because you're going to have the final assessment the final take-home paper will be released, I think, on a Saturday next week. And so therefore, if we had the assessment revision on a Thursday, you'd only have 2 days, or even less than 2 days, to make use of the assessment topic. So that's why we're doing it this week, and next week we're having the tutorial on freedom of information. Now, as you will see later on, the topic on freedom of information will not be covered in the final take-home paper, but it will still be the subject of a quiz, the final quiz, and it will certainly be the subject of the final tutorial. Now, I'm very hopeful that as a result of tonight's tutorial, you should be in a better position to do really well in the final take-home paper. In other words, if you had missed this particular revision tutorial, you would have missed a lot, not only because you wouldn't have known what the questions were, but what I'm going to do tonight is to actually provide a framework that will allow you to provide better answers to problem-based questions in administrative law. And I'm going to show that in a short while. So tonight, after studying this topic, you should be able to identify the topics to be covered in the final take-home paper, improve your marks by answering case problems well, and then enhance your skills at identifying the legal issues. So my promise is that by listening to tonight's tutorial and actively engaging in it, trying to learn as much as you could, you will be in a better position to come up with better answers in the administrative law exams, because you will develop certain skills at tonight's tutorials, and I will provide you a framework that will assist you in coming up with better answers to the final take-home paper. So that's the promise. Now, so let's begin. So what is crucial to point out is that in the final take-home paper, I will not have any question pertaining to the Administrative Appeals Tribunal. So mainly the questions will relate to judicial review. Okay, so the focus is going to be on judicial review. Now, it is crucial that we remember the 5 elements of judicial review. So before you can say that judicial review is available, there are 5 things that must be established. And I wish to emphasize this because this is the way you approach a problem-based question in administrative law. So this is the framework I'm providing, and then I will provide the details on what this actually means. And I will connect the judicial review elements to the topics. So you will get a better sense. So by going through this, once you see a problem, you actually have a sense on what to do. You have a roadmap. So the first thing is that you need to be able to determine whether the court has jurisdiction in relation to the application for judicial review. Now, when you speak of jurisdiction, jurisdiction can be based on the, so we're not talking at this point of the Administrative Appeals Tribunal Act, 1975 Commonwealth, because as I said, that will not be part of the final take-home paper. So the focus is on judicial review. So going back to the issue of jurisdiction of the court, there are at least three legal bases for the court's jurisdiction pertaining to judicial review. One is the Administrative Decisions Judicial Review Act of 1977 Commonwealth. And so the ADJR Act was enacted by the Commonwealth Parliament mainly in order to, in a sense, codify the various grounds for judicial review, which then could be found in common law. So by putting it in that law, in a statute, the various grounds are actually there. So when you look at Section 5, for example, you see an enumeration of grounds. Whereas if you look at common law, which in a sense corresponds to the chapter, to most of the chapters in the textbook, you'll see that there are main themes. But when you look at the ADJR Act, it ends up enumerating different grounds for judicial review. So that's the advantage of the ADJR Act. So one source of the jurisdiction of the court would be the ADJR Act. The second statutory basis for the jurisdiction of the court relates to Section 39B of the Judiciary Act of 1903 Commonwealth. So let me go back to the ADJR Act. Forgot about that. So the crucial point about the ADJR Act is that the Federal Circuit Court, or the Federal Court of Australia, will only have jurisdiction over an application for judicial review if an administrative decision is made under an enactment. So this is a crucial point. Let me just reiterate that. For the ADJR Act to be available as a basis for the court to have jurisdiction in relation to an application for judicial review, there must be an administrative decision, and the administrative decision must have been made under an enactment. So in other words, if the administrative decision, for example, is based on the exercise of non-statutory executive powers, non-statutory in the sense that it did not come from an enactment, but because it involved the exercise of prerogative powers of the executive or the general powers of the executive under Section 61, then in that case, the ADGR Act is unavailable. So what it means is that if the ADGR Act is unavailable because the administrative decision was not made under an enactment, you don't have recourse to the ADGR Act in relation to the grounds for judicial review, and also in relation to Section 12, the powers of the court in relation to judicial review. Okay, so are we clear there? So the other point there is that if the ADGR Act is unavailable, and because there will be a question in the final take-home paper, which will relate to whether or not it's going to be the ADGR Act which is applicable or some other basis for a court's jurisdiction. There are at least two other bases for a court's jurisdiction. One relates to Section 75(5) of the Australian Commonwealth Constitution, which pertains to the original jurisdiction of the High Court to issue writs of mandamus, prohibition, or injunction in relation to officers of the Commonwealth. So you will notice that the particular wording of Section 75(5) of the Constitution relates to officers of the Commonwealth. So that is a crucial point, because assuming that the administrative decision is made by an executive, therefore, not on the basis of a statute, but on the basis of the exercise of prerogative powers of the executive or the executive powers under Section 61 of the Constitution, or the implied powers of the executive, then the ADGR Act is unavailable, but perhaps Section 75(5) of the Constitution is available, but only in relation to the High Court, and only in relation particularly to the writs of prohibition, mandamus, and injunction. Of course, we know that the High Court has also said that part of its jurisdiction pertaining to the issuance of writs of mandamus, prohibition, and injunction would also be the issuance of writs of certiorari, which relates to the quashal of a decision made by an officer of the Commonwealth. But the writs of mandamus, prohibition, and injunction were known as constitutional writs, which means, therefore, that it is difficult for the Commonwealth Parliament to come up with ouster clauses that deprive the High Court of its original jurisdiction to issue these writs of mandamus, prohibition, or injunction. So are we clear? So we've talked about the ADGR Act. It must be made under an enactment. Now, if the administrative decision is not made under an enactment, but because there was an exercise of a non-statutory executive power, then examine whether or not Section 75(5) of the Constitution is available. But again, the problem there is that you are limited to the writs of prohibition, mandamus, or injunction, and certiorari. Now, there is a statutory basis for the court's jurisdiction, another statutory basis, and that is Section 39B of the Judiciary Act of 1903 Commonwealth, and that relates to a similar power of the federal court to issue writs of mandamus, prohibition, or injunction against officers of the Commonwealth. So that's a similar power of judicial review, but this time pertaining to the Federal Court of Australia. But again, the problem there is it's limited to the writs of mandamus, prohibition, and injunction. And again, that one arises when the decision is not made under an enactment. Because otherwise, if the decision is made under enactment, go for the ADGR Act. Clear?
Excuse me, Manjo.
Yes.
It's Monique. Just wondering if you could quickly summarise why you would suggest an action under Section 75(5) for the High Court, or versus Section 39B of the Judiciary Act.
Very good. So what we need to remember is that the High Court, being the highest court of the land, will only entertain matters or cases which are of national significance, in the sense that it is really important to the Australian politic, or two, because it involves a question of law that is non-conventional and therefore requires perhaps an examination of existing legal rules and whether or not there is a need to change those legal rules. So in those two instances, the High Court may most likely be willing to accept jurisdiction of an application for judicial review. But otherwise, if the High Court feels, for example, that it is not too important to the national politic, or the legal principles involved are not that significant, then it will remit that matter or that case to the federal court for determination. And that is in fact under Section 39B of the Judicial Act of 1903. So if you know that it is very important, because it's a big thing, go to the High Court. But it is very unlikely that the High Court will accept jurisdiction. It's safer to go to the Federal Court of Australia, because that's where the most of these administrative law cases involving questions of law should actually be threshed out. Okay, so we're good there. So we've discussed the ADGR Act, we're clear. We've discussed Section 39B of the Judicial Act of 1903 and Section 75(5) of the Commonwealth Constitution. There is a third basis for the jurisdiction of the court, and that is what is known as common law jurisdiction. So what common law jurisdiction represents is that, if you remember the case of Entick versus Carrington, the courts have emphasized and asserted their right to police and supervise the actions and decisions of the executive to make sure that they comply with the law. So even in the absence of any statutory basis, meaning even in the absence of authorization from the Parliament, or even in the absence of authorization from a constitution, the courts have asserted that they have the power to police or supervise and decisions made by the executive. So that is known as common law jurisdiction. Hang on. So from Jesse, yes, that's 4. That's right. So ADGR Act, Section 39B, Section 75(5), and then the common law. So are we clear? Now, the question is, which should you go first? I thought you had said 3. I kind of said 3 because one is statutory, one is constitutional, which is Section 39. So in other words, if it's statutory, it's a matter of classifying it. If it's statutory, there are 2 statutory bases for jurisdiction. You have the ADGR Act and you have Section 39B of the Judicial Act. They're both statutory. You have the constitutional jurisdiction, Section 75(5), and then you have the common law. So we're clear on that. Now, moving on, the other aspect is justiciability of the dispute. So before you can say that judicial review is available, you need to know whether the court has jurisdiction. The second aspect relates to justiciability of the dispute. Now, to many of you, when you think of justiciability, you probably equate it to non-justiciability, right? So we remember that as far as non-justiciability is concerned, it tells us that courts will refrain from undertaking judicial review of administrative decisions which involve political questions or involve national policies or involve national security, mainly because the courts feel that these are, one, they're not really legal questions, but political questions. And remember, courts have a duty only to... Can you just give me a second? Give me a sec. Sorry. Okay, where was I? So justiciability of the dispute. So, you've heard of, you would have associated justiciability with the notion of non-justiciability, and where courts refrain from undertaking judicial review of administrative decision because it involves a political question. There are no legal standards that could be used. And so the courts would refrain from reviewing decisions of the executive, mainly because out of deference also to the fact that in a representative democracy, there are certain questions that are best left to elected members of the government, which would be the parliament. So that's non-justiciability. But actually, justiciability connotes two things as well. One is it relates to the notion of matter. So, in other words, the courts, following constitutional law, courts can only undertake judicial review or can only exercise judicial power when there is a matter before it, meaning that there must be an actual controversy involving rights. These rights usually relate to rights to life, liberty, or property. And that's coming from the case of Haddad Parker versus Moorhead, which you would have learned in constitutional law. So there has to be an actual controversy. So there is no room for the exercise of judicial power or for the exercise of the power of the courts in relation, for example, to hypothetical questions or advisory opinions. There has to be an actual controversy, which is what is known as a matter. Now, in relation, therefore, to what is a matter, because we had said that there has to be an actual controversy relating to life, relate to a right or a duty or obligation. The other aspect, therefore, is to ask that question whether or not an administrative decision has in fact interfered with or impaired or affected certain rights or obligations or duties of applicants. And if you extend that further, it can involve interests or legitimate expectations. So that is the other aspect of the question of whether or not there is a matter, there's an actual controversy. That is crucial because that also goes, am I discussing it here? Okay. Because that will also go to the question of the case of ABT, Australian Broadcasting Tribunal versus Bond, where you make a distinction between a final operative and substantive decision as opposed to an intermediate decision where nothing is really resolved. So in that case, it cannot be said that there's really an actual controversy because it's still hanging there. So the second question you need to ask is there an actual controversy? And secondly, whether there is a right or a duty or an obligation of the applicant that has been impaired by the decision of the decision of the executive decision maker. So that's the second part. I'm putting the color of red on these ones because these are going to be part of the final assessment. The one about standing of the applicant, that will not be asked. So you will just have to assume that you will likely see that in the facts the applicant actually has legal standing, so you don't have to get into that. The fourth element of judicial review is the ground for judicial review. So you need to know the grounds for judicial review, and we're going to go into that in a short while. And then you need to determine what the judicial remedy that is sought. So that has to be made up. So we're clear. So I'm going to go back to this in a short while when I talk about assessment topics. So we're clear. So these are the 5 elements that traditionally should be there before you can say that judicial review is available. In the absence of any of these elements, there is no scope for judicial review. Okay, so let's talk now about assessment topics. And the assessment topics will correspond to the judicial review elements, as I said. And I'm doing this because if you remember this, you now have a framework to attack or address a case problem in administrative law. So this is the framework that I'm suggesting so you don't miss it. And the beauty of the framework that I'm suggesting is that it is easier for you to determine what the legal issue is. Because remember, and as I will explain later on, identifying the legal issue is crucial because it then leads you to identify what the relevant rules are, because the relevant rules, when they are then applied to the facts, will help tell you whether or not the administrative decision is lawful or not, and whatever remedies of the courts might be present. So I'm going to provide a framework. So what are the assessment topics? One is important for you to know the jurisdiction of the court. So familiarize yourself with the ADGR Act of 1977, Commonwealth. We've discussed that. It has to be under enactment. Section 39B. It's writs of prohibition, mandamus, or injunction against an officer of the Commonwealth. Same thing with Section 75(5) of the Commonwealth Constitution, which relates to the original jurisdiction of the High Court, and then common law. We've discussed that earlier. I also said that you need to be familiar with the sense of justiciability of the dispute, I'm talking too fast. Sorry. I'll slow down.
Manjo, are you going to make this PowerPoint available to us?
I will.
Thank you.
Okay. Sometimes I get too excited, so I'm just going to slow down. Justiciability of the dispute. As I mentioned earlier, there are two critical matters here. One is that there has to be a matter, because under the Australian constitutional law, the court's judicial power can only be exercised in relation to matters. So that's clearly under the Constitution. So a matter, there has to be an actual controversy regarding rights. So in relation to that, if an administrative decision does not impair a right, then, as you would have seen, there is no scope for judicial review. So you always ask, has a right been impaired? Or, if not the right, is it a duty or an obligation which has been affected by an administrative decision? And extending it further are questions about whether or not there is an interest or a legitimate expectation of an applicant that has been impaired by an administrative decision. So you need to determine that. Okay. Now, the other aspect is, the second aspect relates to the decision of the Australian Broadcasting Tribunal versus Bond, where the court said that judicial review would only be available in relation to decisions which are final. So we know what final is as opposed to intermediary or intermediate. It is operative, so it will have a legal effect, and it is a substantive decision. That point is crucial because oftentimes when a decision maker tries to make a decision, there are actually multiple decisions that have to be made along the way. It could be decisions on whether or not he will allow for an adjournment, decisions on whether or not he will allow certain evidence, decisions whether or not when the hearing should be made, decisions whether or not certain evidence should be introduced, and so on. So there are actually multiple decisions that an administrative decision maker makes before that decision maker ends up with a final decision. The question is, could every single intermediate, non-final decision be the subject to judicial review? And the answer of the court in Australian Broadcasting Tribunal versus Bond is no. The decision must be final, operative, and substantive. And there is a pragmatic reason for this, according to the courts. Imagine if every single mini step in the process of decision making, every single intermediate step could be the subject of judicial review. The courts will be flooded with all sorts of cases, and it will only open the floodgates to litigation by, every single decision of the administrative decision maker is then subjected to judicial review. So the court said no in ABT versus Bond. So there will be a question where you will need to sense, is this justiciable, in the sense that, is there a final operative and substantive decision? So I'm just flagging that. So in other words, out of the 4 questions, do not assume that all of the decisions are necessarily final, operative, and substantive. So let us be clear, if the decision is an intermediate decision, it is not final, operative, or substantive, there can be no scope for judicial review. Clear so far? Good. Clear? Okay. So the third element, as we said, is that standing is assumed. So this will not be assessed. So I will not be asking questions about, some organization trying to represent an applicant because the applicant might be impaired or the applicant is unwilling to proceed with an action. We just assume, when you look at the facts, we assume that locus standi is there. So in other words, in your answer, you don't have to address that. Don't address that. Okay? So having said that, what it means is that when you provide an answer in a final take-home paper, you need to explain to me what the basis is of the jurisdiction of the court. That's crucial. As I said, just as a reminder, begin first by checking if the ADGR Act is available, because if it is, go for that. Because, as I said, that's a codification of the grounds, a codification of the powers of the court. That's easier. That's, in fact, the purpose why the Commonwealth Parliament passed that law. But if the ADGR Act is not available, you want to know, can you have recourse under the Judiciary Act of 1903? Or Section 75.5 of the Commonwealth Constitution. If those are not available because they're limited to the risk of prohibition, mandamus, or injunction, or because the action is not against an officer of the Commonwealth. Remember the example where a decision could have been made under an enactment, for example, by the Vice Chancellor of the ANU. The ANU being an entity which was created under a Commonwealth statute. Okay, so in that case, the Judicial Act of 1903 would not be available because the Vice Chancellor is not an officer of the Commonwealth. And then, you need to know whether or not the common law is available. I would imagine that you don't have to go into the jurisdiction of the court as far as common law is concerned, because it will likely be captured either by the ADGR, not really either, but it will be captured by any of the three, the ADGR Act, the Judicial Act of 1903, or the Australian Commonwealth Constitution. So there won't be any need for you to pinpoint the common law as a source of the jurisdiction of the court. We're good so far? Good. Okay, there's a question. Can you review certiorari and jurisdiction? Okay, Mira, I'll try to do that when we go to number 5. We'll go to that. So I'm just gonna go through all of these and then, we'll go to that. Okay, remind me, in case I forget, just remind me. Now, as I pointed out, when you look at the grounds for judicial review, the beauty of the ADGR Act of 1977 Commonwealth is that, in a sense, it has codified the grounds for judicial review. So it has enumerated numerous grounds for judicial review under the ADGR Act. Numerous. On the other hand, if you were to rely on common law judicial review, the grounds for judicial review would have been limited to about 5 or 6 common law grounds for judicial review. This would be, let's say, whether or not there's a statutory purpose has been fulfilled, unauthorized decision making, natural justice, law of evidence, and so on. So these grounds for judicial review are actually threshed out in detail in the ADGR Act. But if you look at the way that the textbook has been presented, the topics there, in a sense, correspond to the grounds of judicial review under common law. Okay, and that is a crucial point to make, because even when we examine the grounds for judicial review under the ADGR Act, those grounds are actually interpreted in light of the common law. So you go back to these previous decisions of the court pertaining to grounds of judicial review when you try to interpret the grounds of judicial review under the ADGR Act. So, for example, whether or not a power has been reasonably exercised. That aspect about reasonableness is actually interpreted according to Wensbury and reasonableness, for example. Okay, so the common law grounds of judicial review are important in terms of interpreting and trying to determine what the grounds of judicial review are under the ADGR Act. So they're not divorced. They're very much related. Okay, now, having made that point, there will be 4 grounds of judicial review that will likely be covered. One is unauthorized decision making, particularly relating to the use of discretion. So that can be questions like, as the decision maker deems fit, according to what the decision maker finds suitable. So those involve the use of discretion. And so there'll be questions, therefore, whether or not when a decision maker makes a decision, whether or not the decision is authorized, even when the decision maker uses his discretion. So you need to look at week 5. When it comes, so the second ground of judicial review you need to examine is natural justice. My focus here will be on legitimate expectations. And rights. So just to be clear, the focus will be rights and legitimate expectations. Okay, so because we will recall that following Kiowa versus West, when a decision maker makes a decision that interferes with or affects the rights, interests, or legitimate expectations of a person, there is a requirement that the decision maker must give that person an opportunity to be heard. The only exception being when a statute clearly provides for natural justice not to be observed by the decision maker. Now, we need to remember that the right to natural justice is of common law origin. So it is a right that is recognized by the courts, or a right fashioned by the courts. And so therefore, because it is a common law right, it can be displaced by express statutory formulation. So it can be overridden by an express, clear language of the Commonwealth Parliament. Okay, but otherwise, so if there is a decision that is made and it affects rights, interests, or legitimate expectations, then the decision maker is required to observe natural justice. You can be sure that part of the examination here relates to, so I'm not sure if I'm giving this away, but let's just say that there is this will involve, license, the issuance of licenses. Now, don't ask me if it's a new license or an issuance of license or a renewal of license, but let's just say it's somewhere there. Now, for MIRA, this is a privative clause right. Is that a privative clause right? Yeah, in a sense, you're right. So a privative clause is a clause in a law which limits the power of judicial review. So that is a privative clause. And there are various ways by which a privative clause can be written to control or limit the exercise of judicial review. It not only relates to whether or not natural justice should be given, but also questions about evidence, question about property value, questions about what's the burden of proof. So, but in general, when you speak about a privative clause, as correctly pointed out by Mira, when a statute expressly and clearly provides that natural justice will not be observed, that is an example of a privative clause. Is that in the exam? No. That's a constitutional law concept. So you will not be asked whether there is a privative clause. Okay, but one of the grounds of judicial review we're focusing on here just relates to the ground to natural justice as a ground of judicial review. In particular, it will focus on rights and legitimate expectations in relation to the issuance of licenses. So I'm just being clear there. We're clear so far? Now, the third ground of judicial review relates to law, fact, and evidence. And here, you make a distinction between limited evidence versus no evidence. And so that will be one of the grounds you're going to have to examine. So if there is evidence, even if the evidence is limited, that will mean that, it will not mean that there is an error of law, or it will not mean that there is a jurisdictional error, for as long as there is evidence, versus an instance when a decision was made when there was simply no evidence. And in that case, that would be a ground for judicial review. Okay. Now, finally, the fourth ground of judicial review you want to examine pertains to Wensbury and reasonableness, which, as we said, is in the ADGR Act. And the focus here will either be discriminatory or unequal treatment, or the capricious or oppressive exercise of power. So that should be easy. Now, we will recall that in the quiz, there was some confusion about discriminatory or unequal treatment. And I want to flag that point in the sense that just because the decision maker previously acted in a certain way, decided in a certain way, it doesn't follow that all other decisions must then be according to that particular decision. Because the decision maker is still required to examine every single application on the basis of its own facts. Now, you distinguish that from those instances when people are really similarly situated. So if people are really similarly situated, they're really the same, then in that case, if there is a discriminatory treatment, that can amount to Wensbury and reasonableness. But if you know that there will have to be variations, because let's say a statute may require things like sex, physical fitness, intellect, years of service, and so on, there might be similarities in many of the elements or many of the requirements, but if there's a difference in one of them, and especially when there is room for discretion to be exercised, it's difficult to argue that there has then to be equal treatment, because there cannot be equal treatment of those who are not equal. So just observe that. So that's menswear and reasonableness. Okay, are there questions so far? What number Q was that? What do you mean by that, Leonie? What number Q?
No, they were asking about the Wednesbury unreasonableness in the quiz, the confusion, and I couldn't remember which number quiz that one.
Okay, I can't remember either. Okay. Any questions so far? So we're clear so far about the assessment topics?
Manjo,
Yes.
just a quick question. The question on Wednesbury unreasonableness, will it be clear? Because obviously the quiz question was not clear, and that caused a bit of angst among all students. So will it be quite clear that it is unreasonable or that it's not? Or is there a little bit of crypticness in it, in the question?
There'll be a little bit of crypticness there. I will like it. There is likely a fact there that is meant to throw you off. Because otherwise, if it's too simple, I might be insulting your intelligence. So
I'm happy for you to insult my intelligence.
Yeah, so let me have a look. Let me have a look. But I mean, I've already told you right now, you know what to watch out for, right? So
I guess the question was, like, in the quiz, you had that red herring, if you like, about the freedom of information, which kind of threw people off. So is it going to be something similar to that?
I can't understand that now. I can't remember what I wrote already. But I mean, I've already told you what to watch out for. And we had a quiz, we had a substantial discussion there. You shouldn't be surprised when something comes out where a fact is purposely thrown in just to make it confusing. You'd know what to do, right? We've had substantial discussions on it. Okay, so we're good so far. We've discussed 1, 2, 3, 4. Let's talk about judicial review remedies, which is the 5th element for judicial review. So the focus of there are 2 aspects of the judicial review remedies topic. One is the specific ones, and then I'll talk about non-substitution of judicial decisions. So there will be 4 particular judicial review remedies that you will need to look into: prohibition, injunction, certiorari, and declaration. Now, I need to point out that these are the common law judicial review remedies, but if you look at Section 12 of the ADJR Act, those powers of the federal court or the federal circuit court actually are equivalent to these common law judicial review remedies. Yeah, so I've got a comment there from Amanda. It wouldn't be a Manjo question. Interesting, without a bit of crypticness to it. Okay. Okay, so okay. So are we clear about that? Focus on these ones. Now, I want to emphasize, because I think there was a question asked, a very good question, I think, who was asked by Amanda, was it? I can't remember now who asked the question, but, you know, about whether prohibition and certiorari and so on. So what we need to remember is that as far as the ADJR Act is concerned, if it is possible for you to apply for those particular orders under Section 12, do it. Okay? Now, on the other hand, if the ADJR Act is not available, examine whether or not prohibition, injunction, certiorari, or declaration is available. I think there was a question from Mira, how to distinguish all of these. So let's just quickly go through a distinction here. So let me just clarify again. If the decision was made under an enactment, look at the statutory powers of the federal court or the federal circuit court. Look at their powers in Section 12, because these are equivalent there. Now, if the ADJR Act is not available, then you don't have a choice. You're likely to rely either on Section 13B of the Judiciary Act, which limits you to prohibition, mandamus, or injunction. So there is no question, there is no assessment question on mandamus, but there will be questions on prohibition or injunction. Now, certiorari, as the courts have said, is ancillary to prohibition and injunction. So it is the courts have said that they have the power to issue certiorari, which is a power to quash decisions made by administrative decision makers. There's also the writ of declaration. Now, so we're not talking about ADGR Act for now. Let me just clarify the judicial review remedies from the viewpoint of the common law and the ADGR Act and the Commonwealth Constitution. So if you rely on the Section 39B of the Judicial Act and Section 75.5 of the Australian Commonwealth Constitution, note two limitations. One limitation is that it has to be against an officer of the Commonwealth. So that's the first limitation there. Now, when it comes to prohibition and injunction, for example, what you need to remember is that in relation to prohibition, as a general rule, not only is the writ available against an officer of the Commonwealth, but the requirement is that, one, there is a lack of jurisdiction or an excess of jurisdiction when the officer of the Commonwealth made a decision, or two, there is a requirement that the Commonwealth officer should have acted judicially. So that's the other requirement there. It is an action or decision made by an officer of the Commonwealth, but that particular officer of the Commonwealth is required to act judicially. And we know that when we speak of to act judicially, it means that he acts like a judge. And what exactly is a person acting like a judge? A person acting like a judge is somebody who provides natural justice, who observes natural justice, gives persons, one, an opportunity to be heard, and two, is free from bias. Okay? Now, certiorari is a bit complicated in the sense that there is a requirement that there must be, I'm not going to go into that, we don't have the time, but it is a requirement that it must be evident that when a court determines whether or not certiorari should be granted, it must be based on the record, it must be based on the face of the record. So I don't have the time to examine that. That's 747. Now, let me just clarify something about prohibition and injunction. Okay, the basic question is, can you apply? So assuming we're outside of the ADGR Act, okay, outside the framework of the ADGR Act because the decision is not made under enactment. The question is, can you apply for prohibition and injunction at the same time? What exactly is the distinction? Because remember, the nature of a prohibition is in a sense to prohibit further action of a decision maker. And we know that there's such a thing as prohibitory injunction, which also means to prohibit further action. Okay, so when you speak of there are two aspects to this. When you speak of prohibition, the main difference there is that, as we said, it is against an officer of the Commonwealth, or at least, assuming we're not talking of the common law, right? We're talking of the Judicial Act of 1903 or the Australian Commonwealth Constitution. The writ of prohibition is only against an officer of the Commonwealth. If we rely on prohibition as a common law judicial review remedy, the requirement is that the decision maker is required to act judicially. Okay? Now, there is no such requirement as far as an injunction is concerned. An injunction can be issued against anyone. Okay, so it can even be issued against a private body, as you've seen in the case of New South Wales versus New South Wales Trotting Race Company, whatever. So injunction is general; it's not limited to public officers. Now, in relation to the legal effect of prohibition versus injunction, usually when it comes to prohibition, there must be a final decision, and the purpose is to prohibit further action in relation to that particular decision. An injunction, however, can be issued prior to the issuance of a decision. It can, in fact, be made to prevent a decision maker from making a decision, especially when you remember that there is such a thing as a writ of preliminary prohibitory injunction. So you can actually ask for both. For example, there is an instance when a board or a decision maker is about to make a decision, prohibition may not yet be available because there is nothing to prohibit there, but he can be enjoined through an injunction from proceeding. So that's the purpose. Now, in that case, why would you need prohibition? Because assuming that the decision maker eventually makes a decision, you want to prohibit that person from, proceeding with a decision. So from MIRA, in stevedoring board, there was a writ of prohibition issued against the board. So that was before the ADGR Act. And so what we need to remember, as I pointed out, is that when there's such a thing as a common law writ of prohibition, and so the common law writ of prohibition can be granted or issued against an entity or a decision maker when that decision maker is required to act judicially or required to observe the rules of natural justice. So the common law writ of prohibition preceded the ADJR Act. So that is available there. So we've discussed the judicial review remedies. Let's talk about non-substitution of judicial decisions. This is the other point. The other crucial point is that when you're asked to provide legal advice, you wanna know if there's a point in seeking judicial review, because even if you can clearly cite the jurisdiction of the court, even if you know that there's justiciability of the dispute, even if you know that standing is assumed, even if you know that there's a ground for judicial review, the question is there an effective remedy that is available? Mainly because, as we said, there are limits to the writs of prohibition, mandamus, or injunction as far as officers of the Commonwealth are concerned. That's one. The second question is, courts in exercising judicial review cannot substitute their decision for that of the decision maker. In general, they can only quash the decision of the decision maker. So that's your other point. And we will recall, following the case of Green versus Daniels, that the court said that even if it recognized that the applicant's rights was in a sense entitled to certain rights under the Act, still it could not make the decision in behalf of the original decision maker, because in general, the power of judicial review is limited. It cannot substitute. It cannot sit in the shoes of the original decision maker, and it cannot substitute its decisions for that of the original decision maker. Clear so far? So there will be no questions on statutory purpose and relevant considerations. Questions? Before we go to assessment type. We're good? Okay. Let's talk about assessment type. There are 4 problem-based questions. They're designed to be completed within 3 hours. So don't spend 12 hours. Don't write an answer that will have about 10,000 words. So I don't know what that will be, but you write as much or as little as is required. But remember that you should be able to do it within a 3-hour period. There is no referencing or bibliography that is required. And please, I ask that you need to observe proper formatting. I'm going to put this in the instructions. You use a minimum of 12 points font size. I have instances when students submitted the case notes with 9 or 8 points font size. I can't read it because even if you use Moodle, you magnify it. There are constraints in what Moodle can do as far as gradebook or grade mark is concerned. So what I can't read, I can't mark. Okay, so that will be a requirement, and that will be part of the marking rubric. Questions so far? We're good. So no referencing, no footnotes. Hang on. Yeah. Let's clarify.
Sorry, there is referencing, but there's no footnotes. Like you have to.
Yeah, there is reference. Oh well. Good point. No, let's clarify that. There no footnotes. So in other words, I won't be very particular. I won't be very particular about the footnotes, but if you could cite the case, cite the case. But I will not be very particular about, whether or not you followed AGLC, whether or not you properly footnoted, and so on. but there should be referencing if you could. Yeah, so reference when you can. Yes?
Manjo, if we're just not sure, so we probably add in a little bit too much information, will you mark us down because you think that we've written too much, or will you just allow it?
I would allow it, but note that if you put too much information there, I'm going to talk about what is known as a brain dump. If you do a brain dump, put too much information which are irrelevant to the legal issue, that diminishes the quality of your answer. It means you're making a guess. And it's difficult really for me to be impressed because this is an open books assessment. So you've got everything there. So if you're just going to dump everything that you've read and hoping that, I'll try to make sense of what you've written, that's not a good way of doing it. So I wouldn't suggest it. So, focus on what you think are actually relevant. So we're good. We could go to Iraq format. So, so far I provided you a framework, right, on how to attack a problem-based question, going through the 5 elements of judicial review: jurisdiction, justiciability, standing, grounds, and judicial review remedy. So for a lot of students, they have struggled with identifying the legal issue. And I think that's a common struggle for students. What is the legal issue? And I would propose to you that one way of identifying okay, let me talk first why the illegal issue is important. Then I'll tell you what you should do. The legal issue is crucial because by identifying the legal issue, you then know what the relevant rules are that will help us determine whether or not there is scope for judicial review and whether or not certain judicial review remedies are available. So if you misidentify the legal issue, you will be unable to identify the legal rule because the issue and the rule are always connected. Now, if you say this is the issue and then you identify a different rule, then something is wrong. Okay? The legal issue delimits and will identify for you the legal rules that you will discuss. And those legal rules will elucidate, and when they are applied, will help you to determine whether or not there is scope for judicial review and whether or not there's scope for a particular judicial review remedy. So that's why the legal issue is very important. Okay? That's crucial. And a lot of students end up doing 2 things. They don't attempt to identify the legal issue. They waffle, say so many, but we don't know what the legal issue is. They state what they think is a legal issue, but it's actually a reiteration or a restatement of what are just in the facts. So they'd say, did the decision maker properly apply Section 39 of this particular act? That's just a factual question. It doesn't tell us what the legal issue is. The legal issue, once it's identified, will lead you to particular legal rules or principles. So when you identify the legal issue, it doesn't tell you what the relevant rules and principles are, you've got it wrong. You don't have the legal issue. Okay, so we're clear what the value of the legal issue is. Now, I would suggest to you that there are 5 things, at least for our assessment. There are 4 things you want to examine. They're not always needed, but there are 4 things you will probably examine. First legal issue is, does the court have jurisdiction? And when you ask that question, is the jurisdiction based on, can you base it on the ADGR Act because the decision was made under an enactment? Can you base it on Section 39B of the Judiciary Act of 1903 or Section 75(5) of the Constitution because it is against an officer of the Commonwealth? So these are questions about jurisdiction which you need to identify. As I said, if the decision is made under enactment, go for the ADGR Act because it's simpler, because it's a codification of the grounds and the powers of the court in relation to judicial review.
Excuse me.
Yes, Monique.
Sorry, Manjo. So when we're trying to formulate the legal issue, do you want us to address those 4 areas?
No.
Or you just wanting us to use those as prompts to help us to identify the legal issue?
Just prompts.
Yeah, okay, thanks.
Gives you a sense, how do I identify the legal issue? Okay, have I examined jurisdiction? Have I examined justiciability? Have I examined grounds? Have I examined judicial review? These are just roadmaps. You don't have to go through all of them. But if I remove them, if I don't tell you this, it's just blank, right? Where do I begin? Can you see the difference? But if I tell you those are what you look for, you have a sense, okay. Because in fact, jurisdiction, when you think about it, there are relevant legal rules pertaining to jurisdiction, especially in relation to a definition of an enactment. Australian National University versus Burns or Griffith University versus Tang have discussed when a decision is made under an enactment. So that gives you a sense. And then we know what justiciability is, which tells you, has a right or a duty or an obligation be impaired by an administrative decision. That's the critical question there, because if the person has no right or an interest or legitimate expectation, how can there be scope for judicial review? So that's the basic question. Yes?
Thanks, Banjo. Sorry, I just have one more. Along the same lines, are we to look for multiple issues in each question, or is the question that we need to answer going to be, I guess, clarified by the way it's worded?
In all likelihood, you need to examine it comprehensively. So in all likelihood, there will probably be multiple issues you need to confront.
Okay, thanks.
Okay. Now,
Banjo.
Yes.
So are we not going through all those elements because there's going to be multiple issues and we're not going to have time to say, to explain every element?
Let's just say that there are some which we can quickly discuss, like the question about jurisdiction of the court. And that's easy, right? If it's under enactment, bang, you've covered it. Justiciability, easy, because you simply ask whether or not certain rights or duties or obligations have been impaired. They're quick. At any rate,
yeah. So we can still cover them. We can just do a sentence saying it's relevant here because blah blah blah. That's it. Go on to the next element, so that we've at least addressed it, instead of just giving you an answer and you don't even know how we arrived at it.
So if you feel that it is relevant, because it seems to be relevant in the facts, then raise it as a possible legal issue.
Okay.
Okay. Now, grounds for judicial review, I've also already told you what the potential grounds are of judicial review. So you need to examine whether there is a ground for judicial review, and then the judicial review remedy that is sought must be made up. We're clear? So I've suggested a way to identify the legal issue following these 5 guides. And then the issue will tell you what the rule is. So based on the issue, you can then discuss what the relevant rule is, apply the rule to the facts, and that will lead you to a conclusion. So that's why you notice the IRAC format is very important. Now moving on. So follow the IRAC format, follow the IRAC-CIRAC format, because there is logic to it. So let me just go conclusion, initial, state your conclusion first. You have plenty of examples in my suggested answers where I just say, this is, you should suggest that you apply for judicial review, or you shouldn't. That's an initial conclusion. The issue, make sure to properly and thoroughly identify the legal issue or issues. Rules, state and explain the relevant rules and legal principles. So if you're saying natural justice, reasonableness, and so on, you need to explain those concepts. If you're citing them, I need to know you understand what you're talking about. You also have to make sure that you don't just drop the names of cases without explaining what it is you are trying to establish. So if you cite a case, tell us what the case is about. Now, the crucial point, and this relates to a point raised by one of you earlier, forgot to ask the question, there is no mark for exigently stating legal principles or cases that are irrelevant to the legal issue. So this is an example of a warning against doing a brain dump. You should only be citing legal principles or cases that are relevant to the legal issue. If they're not, don't put them there. It's a waste of your time. It's a waste of my time and a mark. It diminishes the value of your answers. Okay, it diminishes the value of your answers because it tells me that you're not sure of what you're doing. So only focus on the legal principles that are relevant. And you will know if it's relevant if you've properly identified the legal issue. So we've talked about applying the rules to the facts and conclusion. You can end your answer with in conclusion or hence or thus, blah, blah, blah. Okay. Moving on, we're almost done.
So, Mandrew, sorry, it's Lois.
Yes.
So if we do not get the legal issue right, and like we go along with something else that we thought might have been the legal issue, but turns out it's not the right legal issue, so we will get 0 marks. Is that what you're saying?
No. It's not really. It's not either 0 or full marks. I do give marks for attempts. So if they're kind of reasonable,
okay,
I give marks. I don't ever give 0 if something is written.
Okay.
So it's wrong. When I look at it and I sense this is a reasonable attempt to identify the legal issue, there will be marks, but you're not going to get the full marks if you misidentify the legal issue.
Okay, thank you.
Okay, now, so we're clear about that. I agree, that was a good question from Lois. So techniques in answering case problems. Your job is to tell us, or the marker, what you know. You will be marked based only on what is written. So if it's not written, it doesn't get marked. Let's be clear about that. It might be in your mind. You might say that, I know what this means, but if it's not there, we don't mark that. I don't mark that. I'll be the only marker, by the way. So you should just tell me what you know. Okay. Now, write in such a way that you can be understood. Don't force me to figure out what you're saying. Honestly, we had a law discipline meeting today, and I flagged my concern that, unfortunately, there were just several instances of case notes being written where, unfortunately, what was written was simply incomprehensible. I couldn't make sense of what was written. And in a sense, it's disappointing, it's concerning, because remember, English is not my first language. And I would actually expect more from, you guys, because English, for most of you, would be your first language. But somehow, there were problems with rules of grammar, rules of proper English composition, and so on. So I would strongly suggest that before you submit it, try to make sure that you've reviewed grammar, although that can be a problem if you don't really know what the rules of grammar are. But that was just something that really concerned me, because there were some who struggled with rules about English composition, rules about grammar. And if I can't understand what you're saying because they're confusing, then it doesn't go well for you. And you need to remember that when you become a lawyer, or when you become lawyers, a lot of things you're doing would be writing. You'd be like writing briefs, you'd be writing pleadings, and so on. You'd probably be writing a possible order for the court. And if you've got issues about writing, it won't look good on you. So just look at that, because I had major problems when I marked the case notes. Now, thirdly, as I pointed out, please do not do a brain dump. So a brain dump is an instance when you just put concepts after concepts, and they have nothing to do with the legal issue, because it's a waste of your time, waste of my time, and it diminishes the quality of your work. I'm not impressed, especially with the brain dump, because this is an open book assessment. Your book is in front of you, so if you keep on just copying and pasting stuff from the book, or even paraphrasing them, it doesn't impress me, because this is open books. So please do not do a brain dump. There's no mark for simply copying or pasting text from other sources. So as I said, that's part of the brain dump. If you're just copying and pasting text from other sources, it's not helpful. You need to paraphrase, in other words, as well. Otherwise, there is no intellectual contribution. So in some of the case notes, which I really didn't like because it was already in the guidelines, some people just copied and pasted text from the case or whatever. You can't do that. I need you to use your own words, because by using your own words, it tells me whether or not you understand what you're saying, and it is also a way by which you're able to make use of the sources and use it to advance an argument. Okay, so paraphrase. Now, this is another point. I've had about 2 or 3 students where the level of plagiarism was quite high. I was tempted to file an academic misconduct report. The thing is, Turnitin easily captures plagiarism. You'd see the similarity because you can do a comparison. In this instance, I just warned the students, but please avoid plagiarism. They're going to be very obvious. Now, there are at least 2 kinds of plagiarism. One is the blatant plagiarism, where it's obviously copied from some source. It hasn't even been referenced. Okay, that is blatant plagiarism. The other kind of plagiarism is when, that's the only plagiarism, I think. Sorry. So when you copy something and then you don't acknowledge the source, it means therefore that you're claiming the ideas as your own. That's plagiarism. Oh, so there are 2 kinds of blatant plagiarism. One is pure copying and pasting, and you don't cite the source. That's the blatant plagiarism. There's another plagiarism in the sense that you paraphrase somebody else's idea, but you do not reference. That is also plagiarism. Okay? Now, the plagiarism in the sense that you paraphrase is probably not too much of a problem in an assessment such as this, because, as I said, I provide a little leeway concerning referencing, but the blatant plagiarism, we just copy and paste, make it appear as if those were your own words, when in fact you just lifted them from a source. That's blatant plagiarism. And I can assure you that if I see that the level of plagiarism is high, I will file an academic misconduct report. I didn't file it against anyone at this point because I didn't want the student to be burdened going towards the final assessment with an academic misconduct report. But I gave a warning. But please turn it in, catch us these instances. So that just as a fair warning. As well, techniques, use connected prose and coherent sentences in your answers. Avoid answers also that may, so that's a different one. Use connected prose and coherent sentences in your answers. So sometimes it's like, this is what is being discussed, and all of a sudden there's a new train of thought which is unconnected. They're kind of disjointed. It's as if like there's a very incoherent argument that's going on. Just look at that. Make sure that they're readable, easy to read, understandable. Certainly avoid answers that mainly use bullet points. And please review your work for grammar, spelling, punctuation, and formatting. Because on the one hand, one of the marking criteria will be language use and formatting. That's going to be one of the marking rubric. But in a sense, there is a double whammy if your grammar, your spelling, and formatting are poor, because when your grammar is bad, your sentence construction is bad, it affects the quality of your statements, because in a sense, it's difficult to understand what you're saying. It's difficult, so it's in a sense, it's double whammy. It's difficult to escape from the fact that when you don't write properly, what it means is that it diminishes the quality of what you're saying. So you need to review your work for grammar, spelling, punctuation, formatting. Okay, so having said that, we have covered the topics to be discussed in the final take-home paper, improve your marks by answering case problems, and then enhance your skills identifying the legal issue. So I'm done. Any questions that you might have? Questions? Are you still there?
Yeah.
Oh, okay. So we're good. Questions, comments?
We're all in shock. We're all stressed.
Stressed? I was thinking it's going to be easier after the tutorial. Yes?
I thought it was really helpful. I was just wondering if there's a rough time tomorrow that we could check our grades, or if you'll just post on Facebook, let us know that you're going to pop them up.
Yeah. It's likely going to be around 10 or 11 p.m. tomorrow night, because I need to do a moderation still.
Okay, thank you.
But I'll send out an email saying that the grades are visible, but the grades will not be out before 10 p.m. It will likely be between 10 and 11. Now, the PowerPoint slides, I'm going to post them in Moodle tonight or tomorrow at the latest. But I'm hoping that the session was helpful. Okay, so we're good.
Very helpful. Thank you, Manjo.
So good night, and see you next week. Bye.
Bye.